Race discrimination has been an important issue across the world, and specifically in the United States. This has led to Brown versus the Board of Education, which established that the separate but equal education and other services were not equal. It is a Supreme Court case where the justices ruled anonymously that the children's racial segregation in public schools was unconstitutional. The main issue was whether the 14th Amendment was violated by denying education in a specific school based on the difference in races. Prior to this case, lawsuits were filed between 1950 and 1951 in Kansas City, South Carolina, Virginia, Delaware, and the District of Columbia on behalf of the black elementary school students attending legally segregated schools. In these cases, the court's decision was against racial segregation and discrimination, and today, the segregated schools have been held to be unconstitutional, and people are generally permitted to participate freely in other sectors of their life. Flowing from this topic of racial discrimination and segregation or racism would be defined. The Cambridge Dictionary describes it as an unfair treatment given to someone because of their race. It has also been defined as a prejudice or antagonism by the individual community or institution against a person or a group based on their membership of a race or ethnic group, which is typically a minority group. The legal issue for competing for recognition is whether racial discrimination has its effects to the educational sector. According to Maya Agnulu, the prejudice is a burden that confesses to the past, threatens the future, and renders the present inaccessible. This means that the issues of racism affect the growth of any society. This is because such communities would rather spend time on frivolous surrounding discrimination than focus on employing diversity to advocate for the initiative solutions. At the end of this brief, we should understand why, according to Desmond Tutu, if you are a neutral in situations of injustice, you have chosen the side of the oppressor. Why should we continually advocate for elimination of racial discrimination, and what failure to promote this advocacy may cause it to future generations? In light of this recourse, we will be made to the case of Brown versus the Board of Education. The case involves the applicability of provision of the 14th Amendment to the U.S. Constitution to the practice of the Educational Board of exclusion of black students from attending public schools. Here, Brown took a look at Linda, his daughter, for the enrollment in white-only schools because he was fed up with the sight of his daughter going to school far from home because she was black. Sadly, the principal of the whites-only school refused her enrollment. It is important that provisions of the 14th Amendment to the U.S. Constitution provide that no state shall make or enforce laws abridging the privileges of the immunities of the United States citizens, nor shall any state deprive persons of liberty or property without due process of law, nor deny to any person within its jurisdictions the equal protection of the laws. The first affirmative argument: the separation of children from others of similar age and qualifications solely because of their race generates a feeling of inferiority as their status in the community that may affect their hearts and minds in a way too unlikely forever to be undone. Claim: in Brown's case, for instance, Brown's family's lawyers argued that segregation by law implied that African Americans were inherently inferior to whites, and it was even sad to realize that the decision of the court in Plessy versus Ferguson supported the discrimination. Ground 1. The separation of discrimination of children based on their race may affect their psychology. One can only imagine that the state of shock encountered by children when they learned about the George Steiny Jr.'s chair electrocutioning in 1944 and his innocence 70 years after. Ground 2. When children of students feel that their rights are affected, of freedom to associate freely in an environment is disrupted, it affects subsequent rights such as the right to speak due to the fear of being prosecuted. Impact. The impact of courts, legislation, and decision is advocating for equality has led to exclusive and diversity policies even in employment by companies. Opening academic awards and scholarships to people irrespective of race, gender, has given people better opportunities to excel now withstanding their disabilities or privileged positions. Opposing arguments. First, opposing argument: I negate that the separate schools for non-whites were equal, and teachers' quality in those schools is comparable. We argue that because some federal funds were only acceptable to non-white schools, it is a possibility that some programs for minority children were better than those offered at white-only schools. Also, we argue that racial discrimination is not harmful to children, but a redirection to other institutions due to the policies and rules in place. We argue further that if people keep employing empathies to the law's position, the entire structure of the law will fail. Therefore, it is important that the law is regarded as the law and compelled with sense. It does not the fundamental human right to educate, but serve as the redirection to other credible institutions worthy of taking those candidates and students. In the light of the arguments conveyed, we conclude that this argument by stating that discrimination in schools is prevalent and affects student psychology. We further advocate that such policies are unfair and it is no excess that students have alternatives of other schools. It is unfair that an admission process is unmeritorious and directs a student to other institution, notwithstanding that such student enrolled earlier than a student of a different gender or race.